We are Bay Immigration Law. We're a boutique immigration law firm based out of Palo Alto, California, with offices in New York, Florida, and Toronto, Canada. We work with companies of all sizes. We do work with entrepreneurs and innovators, but a lot of our clients are corporates, meaning scale-ups, multinational enterprises, and companies with affiliates in the United States and abroad. Today, we'd like to talk about some of the visa options available to U.S. corporate clients and some insights as to how to make the process as smooth as possible. As a corporate client, you're obviously concerned with cost and timing of the process. Some projects are critical and require an employee to be in the United States very quickly. Other projects may have a longer timeline, but in either case, we can work with you to figure out what is the optimal path and what is the optimal process from a cost and timing perspective. Due to lack of information online, or perhaps a lot of overwhelming information with respect to visa types, a lot of corporate clients are under the impression that there are very few and very rigid options available to them. This is not the case. There are visa options available for clients and for employees who have just recently graduated from college, for example, up to managers, executives, and perhaps specialized employees who might qualify for visas like the O1 or the L1B specialized knowledge visa.
My name is Patricia Limico. I'm the supervising attorney at Bay Immigration Law. We offer our clients both non-immigrant and immigrant options. Non-immigrant options tend to be anywhere from 3 to 6 years, depending on the visa. Immigrant options are those that are looking for long-term permanent residence in the U.S. The non-immigrant options range in the type of employee you're looking at. It can be anywhere from entry-level to multinational executives to extraordinary individuals within their specific industry. So J1s are very much an entry-level visa. We use it as a bridge in many cases when other visas aren't available at the moment. A J1, you can either be an intern or a trainee. So an intern is someone who's still within school or they just graduated within the last year. A trainee has already graduated, has some work experience. That is a requirement. The pros of a J1 is that it's fairly quick. It's not adjudicated by immigration, it's adjudicated by Department of State, but it does require you to exit the US. If you are here, go to the consulate in your home country, get a visa stamp and re-enter. But it is fairly quick, about 4 to 7 weeks turnaround from beginning of the process to actual visa issuance. The downside for some countries, not for most European countries, but for some, is that there is a 2-year home residency requirement, which at the end of the program requires you to go home and spend 2 years abroad. The next visa a lot of individuals will use once they've graduated from school is an H-1B. An H-1B is a specialty occupation which requires a bachelor's degree at minimum in a specific field. So for software developers, you're looking at a bachelor's degree in computer science or engineering or something of that nature. And the position they're being offered by a US-based company is one that requires that degree. H-1Bs are good for up to 6 years, the first one being good for 3 years with the ability to extend for an additional 3 years. The downside to an H-1B is for new H-1B recipients, there is a lottery. So you file at the beginning of April, and within the first 5 business days, all cases received by immigration are included in that lottery. There are 65,000 spots, with an additional 20,000 spots if you hold a U.S. master's degree. So those with U.S. master's degrees have a better shot at achieving that H-1B lottery position. The downside is you don't get to start until October 1st. That is the first day that H-1Bs are allowed to work in the U.S., but it does give you 3 years with that company. Although the H-1B visa tends to be a very popular visa for students once they've graduated, especially those based in the U.S., there are other visa options that you can pursue if you don't want to wait for the lottery or if your specific degree doesn't fit the industry you're looking to enter. You have the option of an L1A or B or an O1. The L1A and L1B are based on your previous work experience at an entity outside of the US. So there does have to be a foreign entity you worked at for 1 year at minimum within the last 3 years. And the US company you're coming to work for has to have a relationship with that entity. So for example, if you've been working for a company in Russia and you want to come to the US, that company can open a US office or a subsidiary and transfer you to that office. So you can either come as an L1A, which is either an executive or a manager, where you've held that role abroad and now you're coming to open a new office and work there. Or you can come as an L1B, which is someone who has specialized knowledge. So if your company abroad has developed a product or a specific service that only you can help bring to the US, then you would pursue an L1B. Then the other visa option that has become very popular, especially with our clientele recently, has been the O1 Extraordinary Ability Visa. So the O1 is an Extraordinary Ability Visa. It's good for 3 years at the onset, and you can extend it indefinitely in 1-year increments. You have the O1A, which allows for founders and product development specialists, but then you also have the O1B, which is for the creatives and the artistic directors and the designers. So it's a visa that captures different fields and gives great options to those that are coming in that don't fit into, let's say, an H1B because their degree may not be based on that or their experience is on something else, or the L1 where they didn't work abroad in this particular company. So the O1 gives them that option to be an expert within their field and come into the US and use that expertise. Our firm can file them in approximately 4 to 6 weeks. Immigration allows you to premium process the case, so you have a decision in 15 calendar days. So it is a pretty quick turnaround in comparison to, let's say, an H1B, where you don't get to start until October. You have to wait. There's a requirement. The O1 doesn't have that requirement on start date, nor does it have a cap or a lottery. We work closely with the employer and the employee to ensure that all documentation is provided for immigration purposes. For example, for an L1A, we will ensure that the company provides all corporate documents, all financial documents that immigration requires. For an O1, we'll draft the recommendation letters. We try to make this as painless as possible for both the petitioner and the beneficiary.
Now, a lot of corporate clients do have general counsels on staff and in-house attorneys who specialize in a variety of areas of the law. But immigration law is quite particular. There are a lot of nuances, a lot of niches, a lot of pitfalls that clients and beneficiaries could fall into. And we as immigration specialists focus exclusively on these questions, on regulatory issues, on process and optimization. So we definitely have a lot of value add, not just to the HR departments of the corporate clients, but to their legal teams as well. So some of the benefits of working with us as a boutique immigration law firm is that we offer a lot of accessibility to our staff. And we are absolutely flexible in our approach to solving your immigration questions. Some clients come to us and they think that they know what the optimal strategy is, and they ask us to file this petition or that petition. But before we engage in document collection, before we engage in speaking with the beneficiary and figuring out what their background actually is, we like to understand what is the short and long-term strategy for bringing this person on board in the United States. As part of this process, we review the options that our corporate client has considered and figure out if they're optimal or perhaps there is a better option available to them given what they really want. For example, instead of filing an H-1B for a specialty occupation employee, they may be eligible for an extraordinary ability visa, given their specialized knowledge and standing in the industry. Extraordinary ability visas do provide a lot of flexibility and take away the uncertainty and the highly rigid structure of the H-1B application process. Having worked with a lot of startups, we certainly understand how critical the factor of pricing is for bringing over an employee. And we work with a lot of our clients on an individual basis to work out a pricing schedule that works for them and for their HR budget. So for our longer term clients, we definitely offer a preferred pricing plan. And we do offer discounted rates on a per case basis. And we are a fixed fee firm, so we don't charge in 15 or 10-minute increments and for answering your emails. That's on the house. So we understand that immigration can seem like a daunting task and a highly complicated process, but we strive to make it as simple and as smooth as possible. We want to stress that it doesn't have to be part of your hiring decision. We want you to pick the best talent available anywhere in the world and let us worry about the process of how to bring them over. For more information, I encourage you to contact us, visit our website, or just give us a call.